there, and welcome to our webinar, where we'll be looking at the upcoming changes to charity law in Scotland. My name is Tracy Bird, and I run the SCVO Trustee Network, which is sponsored by CCLA, who are the UK's largest charity fund manager. So thank you all for coming along today, and while people are still joining us, because we are expecting quite a few people along today, do take the time to introduce yourselves in the chat. And maybe tell us a bit about your thoughts about the upcoming changes to charity law and how they might affect you and your charity. Just to note that we are recording the webinar, but if you've got any kind of confidential issues that you want to discuss and would rather not do that in this session, you can get in touch with us afterwards. We'll be sending out all the slides to you and a follow-up email and follow-up resources as well. So do put the questions in the chat as we go, and we'll be asking our legal experts to take a look at these at the end. So I'm delighted to be joined today by Charles Willis from OSCR, the Charity Regulator, and Debbie McElwraith Cameron and David Smith from the Charities team at Turcan Connell. Turcan Connell have provided advice for SCVO members for many years as part of our free legal advice service. And this is open to any SCVO member with an income of less than £500,000. So I'm going to hand over to Charles Willis from OSCR to give a presentation on the charity law changes. And I am going to share his slides and he will tell me to move on. So if you just give me a couple of moments to get these set up. So, Charles, are they as they should be?
Yes, they are. They're in edit mode at the minute, though, Tracy, rather than view, I think.
That better? All good?
Yes, lovely, thank you. And thank you for offering to do the slides. Tracy has vastly more qualification with regard to IT than I will ever achieve in my life. So, welcome, everybody. I just wanted to go through some of the changes that we will see to charity law in the next year ahead. Tracy, if you could just. Thank you. So royal assent was achieved on the Charities Bill on the 9th of August 2023. There are something like 5 phases of implementation after that. So we have a period of time to allow OSCR and Charities to prepare for the changes within that bill. And what we've done is we've saved the bigger changes until the end, because they're the ones that will need more preparation. So from OSCR's perspective, we've created a database for trustee information. And obviously that takes a period of time for us to do that. There are 3 phases remaining, and we'll talk about those as we go through the presentation. But there are 3 main implementations throughout the year, and I just want to touch on each of those so that everybody's prepared for them. So Tracy, if you could just skip the next one, please. Lovely. So the first one is the publishing of charity accounts. So every charity will need to publish its own accounts on the OSCR online system. Because of the way we're set up, it means that every charity will need to publish its own accounts rather than us publishing on your behalf. So there will be a system in place where you can upload your accounts onto our online system, and they are visible to anybody who wants to see them. This answers one of the key areas that the public, in 2 consultations by the Scottish Government, suggested that we could sort of improve things with regard to charity law, and that was to increase the level of visibility across who's making decisions and where their money is being spent. So it's almost as if they're a sort of a pseudo shareholder within a charity, because they are keen to see where their money goes. The new duty is on OSCR to make those accounts available to the public. So we will provide the system and the charities will provide their accounts. One of the key things I think we need to get across to charities is that we are unable to redact accounts or documents before they are posted. So charities will now be responsible for redacting any information that shouldn't get into the public domain themselves and then to publish. What we will do with that is we can work with charities. So if an error is identified by the charity or by somebody else, if they contact us, we can work with the charity to make sure that we can make the necessary amends and a replacement set of accounts can be published. So we're looking at faces and names in particular of people that shouldn't be shared. The accounts format and deadline for submission will not change. So it's everything is exactly the same as before with regard to the standard of accounts that you publish. The onus will be on charities to ensure that the accounts are publication ready, and we can't stress that strongly enough. We really want to ensure that charities are aware of that and don't fall into any kind of data protection issues. Next slide, please, Tracy. So this particular measure comes in two parts. The first part is that OSCR will be keeping a record of individual charities associated with of individual trustees associated with the charity. We will collect specific pieces of information about that trustee so that basically we are able to identify them. And I think the last figures I saw were that with the information we'll collect about individual trustees will mean there is a less than 1 in 1 million chance that we will identify the wrong trustee. And what I mean by that is if something happens, we will be trying to contact an individual just to say, okay, so let's talk about this. We just want to make sure we get the right person. When I grew up, there were 3 Charles Willises all within 1 square mile of each other. So we're aware that there can be people with the same name living local to each other. And I think the information is, as it says there, the individual's name, their date of birth, the date of appointment as a trustee, home address, and an email address. Now, there are various fixes in place that are too detailed to go through, but if somebody doesn't have, say, an email address, then there are things that we can do to work with those individuals to make sure that there is an email address maybe to somebody in the charity who can then contact that trustee on our behalf. All of that information will be entered through the OSCR online portal. I'm sure some of you will know we have individuals who are able to gain access to the current system, the OSCR online system. The new system will have up to 3 usernames per charity. So with up to 3 people on the system for a charity, we can guarantee that should somebody be long-term sick or away on holiday or whatever, the information can still go up onto our system, or we can engage with individuals with regard to something that has been published. Charities will be able to provide that information from the 30th of June, and I've literally just spoken to our team that is involved with that, and they are saying they feel that it will be available to charities and public alike, to just charities from Monday afternoon, this Monday coming. It all goes live. So watch that space. Have a feel, see what you think, have a look at some of the screens, and if you want, you can start entering trustee data if you have it to hand from then on. What is published will be very different to what OSCR holds. So what will be published will be only charity names. My understanding is that there will be no facility to search for, say, Charles Willis across the register. You will only have the trustee names on the page that relates to a particular charity. And the last thing to talk about there is that dispensation is available, so we can withhold or agree to withhold a trustee's name if there's a risk to personal safety or security of premises. We do hand out dispensation now, but it is not a common process, and we will need to understand what the risk is to that individual before we can grant dispensation. My understanding again is that the way the system works is that if somebody applies for dispensation, then we will not publish anything that about that charity until a decision has been made on the trustee who's applied for dispensation, so that nothing will go up and then come down. We will make sure that we have a decision on every individual before names are published. Could I have the next slide, please, Tracy? Right, and this is another very big one. So automatic disqualification. There have been, since 2005, a range of criteria that if a trustee meets any of the criteria, they are automatically disqualified from holding that post. The number of criteria have been increased and expanded with regard to the different areas that are included within those criteria. We've also broadened the criteria so that they apply to more than just trustees. So we now have a category of individual within charities that we identify as individuals undertaking a senior management function within a charity. That doesn't mean all senior managers, and it doesn't mean individuals who aren't senior managers. That may include volunteers, depending on how the charity operates. Relevant individuals, as you can see, will be automatically disqualified from undertaking a senior management function. That is the law. It's not a decision by OSCR. It is in the law. They cannot be trustees. We will have a waiver process for individuals who have very specific circumstances, and there is a waiver process in place already. So we would expect, say, an individual who has been declared bankrupt, but has specific characteristics relating to them, such as they are somebody with lived experience of drug or alcohol abuse. They may have an awful lot to contribute to a charity that works with people with drug or alcohol abuse issues, and therefore we would feel that a request for a waiver to enable somebody to provide that kind of lived experience to the charity would be appropriate. Again, there aren't many waivers that have been granted, so it would only be under very specific circumstances. Can you move on, please, Tracy? Right, so on this slide, you can see the criteria on the left under the word current. They have been in place since 2005. The new ones that are coming in are the ones on the amber side on the right. And partially this move is to provide a sort of more consistent approach across the UK, across all of the UK charity regulators. Scotland was the last country to update its list of criteria. So we found that we could have been perceived as a weaker form of regulation compared to England and Wales and Northern Ireland. We are now consistent with those other regulators. So you can see again, when you just look at what is written there, you could understand why we would want these measures introduced. So if you've been convicted of bribery or benefiting from the proceeds of crime, perverting the course of justice, being a member or associating with a proscribed terrorist group, misconduct or negligence as a public official, disobedience with an order of court, or sexual offences subject to notification, so being on the sexual offenders register. Now, some of these, being an undischarged bankrupt or having a protected trust deed, have a time limit against them. And so automatic disqualification will only be for a set period of time for those criteria. And my understanding is that people who are disqualified will receive something in writing from the judicial system that says how long they are basically disqualified for before they can apply to become a trustee. Thanks, Tracy. So we did a lot of thinking about what constituted somebody in a position where they undertake a senior management function. And there are two particular cases that we feel that they would meet the criteria for being undertaking a senior management function. So they are in a role that relates to the management of a charity, and they are accountable only to charity trustees, or they have control over money and report to somebody who is accountable only to charity trustees. One of the other discussions we've had was about the word control and what that actually meant. So we were talking about if somebody works for, say, a community hall and takes money on the door, whether they have control over money. And we were clear that these new measures do not include that type of person. It also doesn't include anybody who writes checks, if that goes on anymore, or makes payments to contractors, etc. All of those roles are not included in this this measure. The people who are included are people who are making decisions where money goes to. So they're either setting out the priorities for the year ahead, or they are making decisions on where money should go. Those people then, we feel, are undertaking a senior management function. Okay, thank you, Tracy. Implementation. So very recently, I think it was on the 5th of this month, what was called a commencement order was laid in the Scottish Parliament. And that tells us that the record of charity mergers and applications for a waiver from disqualification will commence on the 30th, so Monday. On the 31st of August, we have updates on the trustee disqualification criteria. So basically, we've done it that way around. So it gives charities a couple of months to make their application should they feel that they need a waiver. And at the end of 2025, and my understanding is now that that is likely to be early 2026, within the first few weeks, I would hazard a guess. Names of charity trustees will appear on the register, and publication of all charity accounts. So we anticipate after Monday, all requests coming from OSCR reminders for charities to submit their annual return. All of those will include something about names of trustees on them, and they will appear as the year develops, as the reporting year goes on. And then within 12 months, we would anticipate having all trustees on the register. Tracy, would you move on, please? So what can charities do to prepare? Ensure that you know who all your trustees are. We have some charities who have literally hundreds of trustees. So collect up-to-date information from them, date of birth, address, etc. We are after the addresses of the individual and not address of the charity. Ensure that your annual accounts are prepared to the style and standard that you would be content to see published. Identify early any trustees or people undertaking a senior management function who may be affected by the new disqualification rules. Update your charity governance material, so induction packs, trustee declarations, all new contracts, staff contracts that are issued now for posts that you feel would fall into the category of undertaking a senior management function. And keep a watch on OSCR's guidance and news updates through our multitude of social media channels. And when we put the slides out, what we'll do is we will include all of our social media links so you can find us online some way. We also have a dedicated web page on our website which has several pieces of guidance or information on the implementation of the measures in this Act. I think, Tracy, that is me done. Yes, so there we are. They'll come round, so don't worry about making a note of them now. So that's us. Thank you.
Charles, there's quite a few questions coming in already. So
Yeah.
what I'm going to do is hand over to our colleagues from Turcan Connell, and I'm sure they'll pull you into the conversation if need be, Charles. So
Sure.
Debbie and David, I'm going to hand over to you now.
Thanks, Tracy, and thanks, Charles. Thank you for having us along today to support you with this presentation. We've been keeping a note of the questions as they've been coming in, and Charles, I think a lot of them are actually for you, but we're happy to assist as we can.
Thank you.
So the first question was, do charities with more than 3 trustees only provide details for the 3 who have access to the OSCR online?
No, it's every trustee.
Yeah. And the next one questions the dispensation point. So do we know what the criteria is yet? Is it case by case basis?
It's very much a case by case basis. There are some people who are at risk of harm more than others. We would need to see individual cases, but there are some charities that invite criticism from other charities. Those I suspect wouldn't be counted unless there was a risk of harm to the individual. There are some people who need to keep their identity to themselves and to make sure that other individuals are unable to trace them. Those we would regard more favourably.
Thanks, Charles. Moving on to a protection question. Someone in the comments has asked, how can we be sure the data is safe, because we're linking date of birth to home address, and questioning potential identity fraud. Now you've already explained that the external register will just be names only, and it won't be searchable by name, but the date of birth and home address will be part of the internal register held by OSCR. And again, not going to assume any actions done by the regulator, but for something like this, we generally expect to see a data protection impact assessment being carried out for something like this.
Yes, absolutely. So I've asked this question of our IT team several times, and they are keen to point out that only some individuals within OSCR have access to that system. So in my role, I would not have access to any of the personal details. It has a new system has multiple levels of authentication, so it takes more than one piece of authentication to get in. It is on a separate server to the main server, and we fulfill all of the key standards that you would expect a government body to need to fulfill. I would never ever say it's not going to happen, but I'm an individual who doesn't gamble, but I would probably put money on this never being broken.
Thanks, Charles. Going back to this point.
Sorry, one of the other things I would say is every year we have to go through some kind of data security training within OSCR. I finished mine this week, and it is fairly exhaustive with regard to what we have to be aware of. So literally for me, just individual things. Oh, if I leave my desk, I have to shut my laptop down, switch the screen off, etc. And even close our notebooks so that there is no writing visible even to colleagues. The public do not, to my knowledge, come into the office at any point and will not see screens either.
Thanks, Charles. I'm sure that's exactly what they want to hear. Going back to the dispensation point, we've got a question about the timeline. And if dispensation is not granted, will the trustee have time to consider their options, such as stepping down? But one of your last slides talked about the time frame. So if we start with the information gathering at the end of this month and applying for dispensation, but it won't be published until, as you say, early 2026, then that gives, approximately 6 months for the trustees to consider their options. Would you agree with that?
Yes, exactly. Yes. And as I said, if an individual notifies us that they are in the process of submitting a request for dispensation, we will not publish. I think individuals have a period of 28 days from notifying us to when they need to provide their request for dispensation.
Thank you.
A lot of this, I would say, is an old man's memory, so forgive me if some of this is slightly off.
Thanks, Charles. The next question is about the disqualification routes and the rules, whether they are replacing or exist as well as, and they are as well as, they're not replacing them. So the list is now lengthier.
Yes, it is. Yes.
And how you upload trustee details. There's a question about whether there's a specific link, but that's done through the OSCR online. So assuming when you log in, there'll be a form to fill in for each individual trustee?
Yes. There is a screen and it asks for names, first name, second name, and then individual details. You upload that and then you go through that process for every trustee.
Thanks, Charles. The next question is whether there'll be a new declaration template. And I think that might be the new trustee declaration when you're establishing a charity. And I don't think that'll change, but Tracy has very kindly popped in an answer that the SCVO have got a template for organisations to use to collect the information. So it's different from trustee data at the beginning of the charity's life.
Yes, I am not in 100% updated on that, but we were going to update the form and make it available.
The next question is, will trustee disqualification be automatic by OSCR, and how will that be communicated?
Disqualification isn't automatic by OSCR, it's automatic by law. OSCR doesn't have a decision on whether somebody's disqualified or not in that respect. But as I say, we have a limited scope for giving waivers to people with lived experience.
And then maybe we can jump in there and add a bit more to that. I suppose this is a good reminder for anyone involved in charities about ensuring you have good governance processes in place. So when you're bringing on board new trustees, new senior management staff, that you're going through that due diligence, which is now expected on you. So the burden really is on the charities themselves. So using that SCVO template when you're bringing on new trustees and asking people that particular question in a timely manner.
I think we do need to make a distinction between at what point in the process this happens. So if you're at the point of induction, so you're bringing on a new trustee or you're bringing someone into a role that has a senior management function, you'd be carrying out the due diligence David mentioned before that person's appointed. So if you find out through your due diligence that they would be disqualified, then that would prevent them from taking on that role. So that's a slightly easier process. If the person is already in position, so they're already a trustee or they're already for example, chief exec or finance director, if when the rules come into force at the end of August, you find yourself in a position where they would come under the new disqualification rules, OSCR have said that because they will start it sort of now and the rules don't kick in until the end of the summer, you've got that period, that grace period to either apply for a waiver or to deal with the matter. Now, how you deal with that will depend on your HR processes, the policies you have in place, and it doesn't automatically mean that that person will be fired. You know, that's not how this is going to work. We've heard people say that, you know, well, charity law is trumping employment law in this case, and that's not how it's working really, although it would make our lives a lot easier when we're advising clients, but that's unfortunately not how it's going to work. So in that case, what you'd be looking to do is obviously get the information as to why that person would be eligible under the disqualification rules, and in accordance with your policies. And if you don't have the policies in place, the ACAS policies, then considering, you know, is this person going to be suspended? And again, that will depend on, does the person have an existing conviction, or is it at the point where they're being charged? Because if they're being charged and they're not convicted yet, so they wouldn't necessarily qualify under the eligibility for disqualification, but it's something that, you know, would come down at a later stage. So really, from our perspective, what charities need to be doing at the moment is making sure they have the policies in place for, you know, due diligence at the point of appointment. What will happen if someone, you know, has a conviction or is charged and then convicted of an offence that would disqualify them? You know, are you going to suspend them? Could they be repositioned within the organisation so they're not in a senior management role? So things like that could be considered at the outset and put into your policies. You know, strengthening your induction period. And if you don't have HR support, so if you are a smaller organisation, you know, looking for that now and knowing where you would go if that matter ever came up, you know, whether you would look for HR advice from an employment lawyer. I know SCVO have resources on their website for that sort of matter. So a lot of it depends on at what stage the person is at as to how the rules impact them. But the best thing you can do is make sure you have the policies up to date, taking into account these new rules, and have the resources ready. And don't forget, you know, employment law rights for your senior management functions when it relates to an employee. So
just moving on to a couple of other questions. I see there one there, just for confirmation, that the public information that will be available is just the trustee's name only that is going to be on that public facing register.
Yes. I would say, apologies for interrupting that.
No.
I would say as well that if a trustee's name isn't, if OSCR's decided that the name shouldn't be published, we are highly likely to put something like name withheld in a box, so that people who are looking at the list of trustees are aware that there are enough trustees there. It's just that we haven't published the names. Otherwise, it may look curious that they only have 1 or 2 trustees.
Yep, so that's very helpful. Thank you, Charles. And moving on to the next question, and this is going back to the redaction of accounts. And specifically, do you need to keep all the names of trustees and senior managers visible? Because obviously they're currently redacted through through OSCR as under the current rules.
I believe. Sorry. Far away.
You go first.
I believe it was I thought it was a legal requirement for the names of trustees to be published. So I would want, obviously, all charities to comply with the law. For us, it would be names of people who maybe had been associated with the charity, names of beneficiaries, etc. That's the sort of thing we're looking at. Photos of individuals who haven't given their consent for their photos to be put forward, etc.
Yeah, Charles, I would agree. I think looking at it from a slightly different perspective, OSCR didn't, and again, please correct me if I'm wrong, OSCR didn't redact the names of people for data protection purposes. It was because as an organisation, you didn't actually have the right to publish that personal data. Yes. And that gap was resolved with the new act. So the redaction wasn't because simply it was a name, it was because you didn't have the power to do so. And you're right, so the trustees' names should be there. And what you're really looking at here is, do you have the consent of say service users whose story you're telling as part of your annual return and your reporting process. So it's making sure you have all that consent in place. The interesting point about signatures, I know that OSCR have encouraged use of type-signed signatures, so you're not actually wet signing it, which could be, people are concerned about fraud from that perspective. A lot of our clients who we assist with their accounts, they will go for the type-signed signature, which is obviously just typing the name. So that sort of takes away the element of concern there.
Yes, absolutely. We're quite happy with that. We are very keen, obviously, to avoid any instances of fraud through this system.
So the next question goes on to talk about the PVG process and how that would fit into automatic disqualification. I think that's something we've actually talked about recently.
Yes, so there have been quite a number of changes to the PVG scheme recently in Scotland, and the criteria of who is eligible. Now, there are only certain people that are eligible for the enhanced PVG checks. I think that under the new legislation or new rules or guidance, these are called level 2 checks, and that shows all history of convictions, whether they are unspent or spent, but they are really they're quite a more significant undertaking, and are really only appropriate for people in regulated roles. So that includes primary school teachers, for example, solicitors, accountants, and people that work in prisons as well. There's some of the examples. So if a charity is looking to employ someone, it is possible to do a level 1 PVG check, but you have to get the person who's maybe applying for the role, their consent for them to carry out that check. They have to volunteer that information, and that discloses if there is any conviction which is still on their record. So that is something that could be introduced. It is not an absolute requirement, but if you wanted to do perhaps enhanced due diligence as part of a new employment process.
Oh, sorry, Charles, did you want to?
Apologies. Yes, I'm aware that Disclosure Scotland and Volunteers Scotland have been engaging with stakeholders with regard to what the changes mean. My understanding is there are likely to be far more people who will now need some kind of PVG certificate, so it would be well worth looking up on their websites what that means for you, and then make a decision yourselves on how you need to go forward. I think there is a grace period at the minute, and also they are suggesting that if a charity can demonstrate that it is starting to make the right steps towards getting PVG checks done on all of the key individuals within a charity, that will be an acceptable situation for charities to be in.
Yeah, and just to add a bit more detail into who's getting caught by these new checks is, so previously if you were running a care home, for example, obviously all of the employees, senior management would be expected to have those checks carried out to them. But actually now it's extending in some cases to the board of charity trustees are now going to have those checks carried out on them as well, even though they're not actually carrying out the day-to-day services. So it's just important to flag that to anyone and just to use those resources that are available.
Thanks, Stephen. The next question goes on to talk about, will we need to get current trustees to redo the declaration for the new criteria? Charles, you've already mentioned that it's likely that will be updated shortly. And for the sake of good governance and ensuring the information you have is up to date, then yes, you would want the current trustees to redo that information just to make sure that not only are they aware that the changes are now in place, but also if you have to carry out any further work if things do come to light that maybe weren't before.
Yes, very much so. I would strongly recommend seeking some form of statement from individuals with regard to the fact that they don't meet any of the criteria. And I would also suggest that you go through that process periodically, maybe once a year, certain criteria can sort of sneak up and bite people throughout their life, such as going through into a protected trust deed or whatever, or needing to. So we will probably be the last people that somebody will be thinking about if they were having to go through the process of getting a protected trust deed. So it would just help everybody if they could be asked periodically. Maybe a good time to do that will be at the time of just before the annual return being submitted, just making sure that you go through that process as a part of good governance.
Thanks, Charles.
Yeah, and we've got another question in terms of, will the disqualification be retrospective?
With the extended rules coming into play, oh, sorry, Charles, on you go.
No, far away, please.
I was just going to say, say, taking an example of a trustee, if when the rules come in, it turns out they are disqualified under the new rules,
Yes.
It wouldn't necessarily be retrospective in that you would have to then do anything with for when it came into force. It would just mean from that point, yes, they would be disqualified from being a trustee. And generally we find in modern trust deeds anyway, modern constitutions and governing documents or whatever you call it, generally the clause on trustee termination or disqualification will include, you know, a reference to the disqualification criteria, and that person will cease acting in that role if they are eligible. So yes, as soon as it comes into force, it will be applicable.
And just to be clear, if an individual makes a declaration that they do not meet any criteria, and it turns out that was an untrue statement, then they will have committed a criminal offence by providing an untrue statement with regard to them not meeting any of the criteria. That, my understanding again is that there is no such crime or criminal activity with regard to the charity accepting an untrue statement. If that makes sense, there's probably a much better way of putting that. I look to my two legal colleagues for that, but we would expect charities to undertake some form of due diligence, but they can't do everything with regard to due diligence checks for an individual. If they, for example, are being processed and going through the judicial system, but there is not likely to be a case for some time ahead, then charities may not be able to find that kind of information out, which is why we will rely on self-declaration.
Yeah, and Charles, that actually effectively answers the next question, which
right.
is it's not reported by the trustees themselves. So there is an element of good faith here, and you know we've talked about due diligence, but again, there's only so many resources that you can check that are publicly available. So yeah, there is an element of relying on the trustees making the declarations. I suppose what can you do if they don't? Well, you've already explained that it would be a criminal offence for that individual, but not for the charity. And it really obviously just doesn't paint them in a good light when it does come to light. You know, they've not been truthful, and whether that has an impact on the consequences. Obviously, I think we don't know yet. It would need to be played out, but a lot of that comes down to, you know, knowing your trustees, knowing your board, carrying out a full induction period. It's difficult, but I think we're putting a lot of trust in individuals to make that information available when asked.
Yes.
Right.
And I think the next point, and this is on PVGs, and in terms of the timing of them being processed by Disclosure Scotland, and whether the trustees can stay in place if the application was submitted in a timely manner. And that goes back to the point you were making, Charles, is there is a grace period, there's an understanding, there's probably a lot of information that Disclosure Scotland are dealing with. So if you as an organisation can show that you're following the correct processes, you're just waiting for that report, then the trustee can stay in place. And obviously, if the report comes back with something that you then need to deal with, then that would have to be dealt with in a timely manner. But I don't think there would be an expectation that your entire board has to stop acting until your Disclosure Scotland responses have come back.
So the next question is, if it was an honest error, the person has not made the sort of disclosures. I think what that question is asking. So I think it would depend on the circumstances, but given the eligibility criteria, I can't see how it could be an honest error. I think you'll know if you're bankrupt, you'll know if you've got a protected trustee, you'll know if you've been convicted of a terrorism or sexual offence. So I think it would be a hard argument to make if you didn't declare it and it was an honest mistake or a mistake. Yeah, I don't think there's much more to add to that one, unless, Charles, you want to.
No, I absolutely agree with you. And as I say, each person, individual who has gone through that process will be told when their conviction expires, so they will know the date. So it would be difficult to see how that could be a mistake.
And the last question we've got at the moment, it's just to confirm. So yes, the new disqualification routes are in addition to and don't replace the existing ones.
Yes.
So yeah, we don't actually have any other questions in the chat box at the moment, but if anyone does have one, please do pop it through. Tracy, is there anything?
I've got a question actually, and it's partly been answered, but I just want some clarification. Obviously, we're relying on self-declaration by trustees, and it's very important to get trustees to fill in an annual declaration. That is good governance. You may have the belt and braces with a PVG check if the trustees are in a regulated role now. However, for something like misconduct or negligence as a public official or disobedience with an order of court, how would you know about that? I mean, is there any kind of register of that? Would that come up in a PVG check or not?
Sorry, Charles.
Sorry, off you go, Turcan Connell.
The results of the PVG is I think limited to convictions. So again, I think it would depend on the circumstances of the other two. I know this is probably not a really clear answer, but something as simple as a Google search, you know, if it's a public office and there's been misconduct in public office, the chances are it's hit the news. So it's certainly worth doing a basic internet search on the person. And if it is someone who's joining your board who is in a public official role, or someone in government or something like that, again, the chances are, if there is any misconduct there, it's going to be public knowledge. There are some registers you can check, like OSCR has a register for those that have been removed by the court. There are some court rolls that can be checked as well. You can check by name. So there are things you can do if you're concerned about someone and maybe the person's not being truthful. But I think a lot of it does come down to case-by-case basis. And depending on which sort of category of eligibility it is falling into. But I think for those that aren't immediately obvious, a good place to start is an internet search, especially for those slightly more obscure ones. No,
appreciate that. Thank you. There's another question come in there from Nicola. If the charity has care providers managing properties, do the trustees now need to be PV checked as well?
Well, there would need to be a regulated or carrying out regulated work, which my understanding is, with vulnerable adults and children. So if the care providers are managing properties and say the properties are being occupied by someone within the definition of regulated work, then they probably would fall under it. But the Act itself, and I think the guidance on the OSCR website and the Disclosure Scotland website does give you a good definition of what regulated work would be. So I think you'd have to look at that definition, look at what the function is that they're carrying out, and see if they would fall under it that way. Just the follow-up there about whether it's good practice, one of the points David made is that some, depending on the level of PVG, you can't just voluntarily get it. Level 1, you can voluntarily get with the permission of the person. But for example, the level 2, you have to be doing regulated work to get that level of PVG.
Yeah, that's correct. No, I don't have much else to add on that. It really comes down to the specific activities of those individuals that are sitting underneath the board. So it's quite hard to give a sort of sweeping answer to that without going into too much detail.
Yeah. And even something like that question is suggesting it's good practice just to do it anyway. Again, we've spoken recently about this, and it was a trustee board, and they weren't sure whether they would fall under regulated work, and it turns out they don't. And again, the question was asked, should we do it anyway? But a PVG check, again, comes at a cost. So it's, do you have the assets to expend on this? Say you have, 15 trustees, and you've got, members of staff as well. Before you know it, you could be doing 30 applications. And if you're not required to do it because you're not doing regulated work, then that is something you need to think about as well as, use of funds in that way.
Yeah. I think we were talking, Debbie, before we came online, around there is a certain amount of disquiet with trustees having their names on a publicly available database. But as you pointed out, if your charity is a company, the details are up there on Companies House anyway. And you did say, I asked you a question about anonymizing trustee names through Companies House. I just wondered if you wanted to share that little nugget as well.
Yeah, absolutely. So yeah, we've had a few clients and contacts be concerned about these changes and the names being available. And I think when you take a step back and explain that, the Charity Commission have been doing it this way, for a number of years. And if you were to go and look at a charity's entry on the Charity Commission register, it has a lot more detail than what the Scottish Charity Register has. And like you say, if you're a charitable company, your names are listed as directors. There is a way to have your name redacted through Companies House, but it is a very, very onerous process. We've looked into it a few times for clients, and correct me if I'm wrong, David, I don't think we've ever been successful because the criteria is so high that it's very difficult to get your name redacted if you're a director of a company. We've actually had instances where clients have just resigned from the role to get to not have their name as a director because they didn't fulfill the criteria to have their name removed.
Yeah, and just to add to that, the one case where I had it was an individual who was in some ways being targeted, that had incidents that they had reported to the authorities, but they had no case reference, no police case reference number, no formal documentation from the police. And that was the first thing that Companies House asked us for, is that authority, that information that Police Scotland were able to provide, confirming that this individual was at serious harm at all times because of their position. And so unless you have that information, that's really one of the only ways in terms of getting that information redacted at Companies House.
One of the things that hasn't come up yet, and a question that I just wanted to add to the conversation, is that if you do have an employee who's performing a senior management function and they find themselves within the disqualification criteria, at the moment there are 5 rules for dismissal, 5 reasons for dismissal, and these new, the new and existing criteria would probably come under a statutory restriction, possibly conduct or some other substantive reason. Now, these rules are 2 years plus rules when someone's an employee, so you need to be in the company or in the organisation for 2 years before these rights kick in. So that you need to take that into account when you are dealing with these situations. That's why we do say, look at your HR policies, get HR advice. But one thing we wanted to flag is at the moment, Labour are changing employment rights and employment legislation. So from probably the end of the summer next year, the 2-year rule is likely to be abolished and there'll be day one rights. So the dismissing someone for, say, a statutory restriction and the rights that go along with that won't be, if someone's been in the position for 2 years, it will be almost immediately. And again, we don't know if the reasons for dismissal will be changed under the new labour rules. So while we have an idea at the moment what it would look like, by this time next year, it might be different. So that's why really, until it's tested, it's difficult to say. But for trustees and for organisations, the best thing to do is just make sure you're refreshing your dismissal policy and taking into account these extended rules, and, like I say, getting advice when you need it, and keeping an eye on employment updates from the Labour government.
Thanks, Debbie. There's another couple of questions in there. Someone saying their trustees are all parents of vulnerable children or adults. So would that be enough for redaction from the annual report accounts? Charles, would that be enough?
That's a very long piece of string that we've just pulled out there. I think we'd need to look at each case with regard to, so trustees, I would expect their names to be there. There's no link unless it says somewhere that all trustees have vulnerable adults as children, then or vulnerable individuals as children, then I think we would need slightly more. I think it would be entirely up to individual circumstances. I think so. We couldn't give an answer to that.
Thank you. And finally, Kevin has raised an interesting point. I think we all know that trustee recruitment is very difficult, and perhaps some of these changes are not really going to help with that. He's asking if there was an impact assessment done on the effect this may have on the ability to recruit trustees.
Do you know, I'm not sure there was on that specific aspect. Impact assessments were undertaken by the Scottish Government, but I'm not sure whether there was anything on recruitment of trustees. That has been a consideration for OSCR. We've been aware of some charities having difficulties, but it's just that's the law, so we have to comply with the law, and B, in some respects, if the public are saying they will have more trust and confidence in the charity sector, then we need to do it. Otherwise, I think the reputation of all trustees will deteriorate if that confidence is lost in the eyes of the public.
Yeah, thank you.
Tracy,
yeah,
sorry.
Debbie, David, I wondered if you wanted to wrap up with any other comments on that.
Just at that point there, I think from our perspective, the names of trustees, so if you're a trustee of a charity, that information is always been publicly available. It's not been on the OSCR website, but it's information that, you know, charities, if someone asks the charity for a copy of their constitution, a copy of their accounts, you know, that information is available. It may not be as visible as it will be with the register, but it has always been available.
Yeah, and I think it's just changing attitudes that we speak to colleagues south of the border where this has been in place for a number of years, and they just don't see it as an issue because it's been in place for so long. So we understand some of the skepticism, maybe some of the worries in terms of data and so on, but I think after a couple of years, when it becomes the norm, I think those worries will potentially fade slightly.
Yeah.
I don't want to, there's a couple more questions. I don't know if you want to try and rush through them, or do you want us to give some comments that we can circulate with the slides later?
Well, there's that one there from Susan, Debbie, if you want to answer that one, and then I'll wind up after that. And just to say, people, if they do think of anything after this, you know, you can ask your questions to us directly at enquiries@scvo.scot, and we will either answer them ourselves or we can send them on to OSCR or Turcan Connell or our other legal partners. But yeah, do you want to answer that one on domestic violence victims and reduction?
The question from Susan,
Yeah,
again, as Charles has already alluded to, when it comes to things like redaction, it is case by case basis, and you're looking at, you know, the safety of a person or their property, and I think, again, depending on the details of this, it'd be one of the stronger cases, I would say, for redaction, unless Charles wants to disagree with me there. And just quickly, there's a question from Alistair about changing the management structure to allow an employee or volunteer to continue in post. One of the things we've talked about in relation to this is the potential to redeploy a person. So if the organisation believes that, you know, it's in the best interest for this person to continue with the organisation, depending on which of the disqualification criteria they actually fall into, you know, there is a possibility of redeploying the person within the organisation, so they are neither a trustee nor a person carrying out a senior management function.
yeah. Thank you, and thank you to all our speakers and you all for taking part today. I think that's been really useful, and I've certainly learned a lot. As I said, the slides will go out along with a new SCVO template, and that's both an updated trustee declaration that trustees are not disqualified, and which really should be completed annually, and it would also help you with submitting your trustees' details to OSCR. As I said, do send in any more questions in that you can think of, and also take a look at our website information on the charity law changes, which is regularly updated. I think we can tell from today there's lots more questions. I think you'll probably think of more as the changes come in. And there's other changes coming in for charities over the year, including some new director ID requirements for charitable companies, new accounting requirements. We've mentioned PVG. So we will be running another legal update in September. So do watch out for that on our events pages. And that's it, 1 minute past 2. So thank you and goodbye.